What happens during an arraignment? Let's say you receive a court notice in the mail telling you you've been charged with a crime and you have an arraignment to attend. What should you expect? Well, there's 4 main goals of the arraignment. Number 1, to appear before the court and be formally notified of the charges against you. The judge or the prosecutor will read the charges in open court. Number 2, to respond to the charges by entering a plea, guilty or not guilty. Now, 99% of the time, the right answer is not guilty. Number 3, to hear the judge decide whether you go to jail while the charges are pending or not. If so, what amount of bail is set? If not, what conditions will you have to live by while the case is pending? You're presumed innocent of the crime at arraignment, and many states, including Washington, presume that you should be released at the hearing and not put into jail. Now, if you miss court often or if you have a bad history, the prosecutor may ask the judge to put you in jail and set bail. Having a stable address, job, family, bills and obligations, and a clean record are all good defenses against jail. The question the judge is going to ask is whether you're a danger to the community if released. It's up to your lawyer to demonstrate you're no danger. Even if the judge jails you, though, they will set bail, which is money you can pay to the court as a promise that you'll show up for court and be good while the case is pending. Even if you go to jail, your lawyer can argue for as little bail amount as possible, so you'll be able to post that bail and go home the same day. But if the bail's too high for you, you'll stay in jail until the conclusion of your case. That could be a long time. Number 4, to make plans for the future. The court will set pretrial hearings, a jury trial, and there are speedy trial deadlines, 90 days from the date of arraignment for cases out of jail, 60 days from arraignment for cases in jail. Now, the sooner you contact a lawyer before your arraignment, the better. How should you act at your arraignment? Here's some tips. Arrive early. The judge is going to remember if you're late. Now, I was in court once where the minute the calendar was called, the judge called roll. All the people who arrived even a minute late for their hearing had a warrant active for their arrest. I thought that was extremely unfair, but the judge can do that if they please. Dress professionally. This demonstrates to the court that you take this matter seriously. Give your lawyer all the info, but let your lawyer do most of the talking. The less you speak, the better. You should give your lawyer all your important information before the hearing: where you live, what your job is, the names and ages of members of your family, whether you have any other cases pending, active warrants, anything that could be pulled up on an official search and used against you. The goal is to make sure you walk out of there freely, so arm your lawyer with the knowledge to fight for you. Ask your lawyer for copies of everything, especially anything signed by the judge. If you fail to follow the court's orders, it's not your lawyer who will be held responsible, it's you. Meet with your lawyer both before arraignment, if possible, and as soon afterward as you can. It may not always be feasible to meet with your lawyer in detail before the arraignment, but you should try to sit down and begin planning your defense as soon after the arraignment as you can. Schedule a meeting with your lawyer when you are with them in person. Finally, remain calm and get out of court as soon as you can. If you didn't go to jail and you walked out of court under your own power, count it as a win. Thanks for watching.